Okay, we'll go ahead and get started. Welcome to today's webinar, GDPR Remediation Projects, Where to Start and How to Still Beat the Deadline. So thanks again for joining us, and today I'd like to introduce you to our Scott Giordano. And Scott Giordano is a data privacy attorney at Robert Half Legal, and he has well over 20 years of experience in data privacy. So welcome, Scott, and I'll hand over the webinar to you.
So let's talk about getting GDPR projects off the ground. I imagine that all of you are on the call because you're either in the midst of getting a GDPR project off the ground, or you're either done that, or you're just started it, or perhaps you've hit some road bumps. So I'm going to address all those things. And like Doug said, if you have questions, send them in. Happy to answer them as we get. So with that, let's do this. Before you even start a project, I'm citing a couple things here that many of you are probably familiar with, but I want to cite them anyhow because I'm just drawing on my own experience on projects of all kinds, not just GDPR projects, but pretty much everything I've worked on over the last 20 years. So I want to share those with you so that you have the benefit of that experience. One of the things that's so important to me about any project is making sure I get executive sponsorship. I can tell you that I've been on projects that have it only in name, don't really have executive sponsorship, and there's no one to run the ball down the field when you need something. Either when you need money or you need resources, you need something, there's no one there to champion the project. And if that's the case, the project's in trouble already. And some of you may have experienced this where there's really no one in charge of the project. At least there's someone nominally, but there's no one that's really cheerleading and assisting you and being an advocate, and that's crucial. Second thing is that there are threshold questions that need to be resolved, which we'll touch upon those in a minute. We'll touch upon assembling your team and getting the right people on the bus and getting them on the right seats and so forth. Talk about the benefit of team charter, and then finally we'll go into project killers. And once we finish, before you start, we'll actually start and show you what you should do when you start. So, so in terms of executive sponsorship, one last point before I talk about our threshold questions is that people ask me, well, is this something that should be led by legal? Is it something that should be led by IT? And my view on this is that because 80% of GDPR is legally driven, really someone in legal, in my view anyway, should be the executive. Perhaps it's the general counsel or someone of that nature should be the executive that's both named and is the one that's being your champion. Secondly, that person, along with the rest of the team members, should address some threshold questions. And again, these are questions that if you don't do these ahead of time, they're going to come up anyway, and it's going to bite you. And I'll give you an example. So who will lead the project? Typically, this is going to be someone who's not the executive sponsor. It's going to be someone further down. It could be their second in command or someone else like that, but there has to be an identifiable leader, and finding that person, again, is very political. It could be someone from legal. It could be someone from IT. It may be someone from HR if you're very focused on HR data, so on and so forth. Second point is, where's the money going to come from? This is probably the most common question I get from folks is, should this come from Department X versus Department Y? And the answer is it should come equally from everyone's department, because I can tell you this isn't a legal or an IT or an HR problem, it's everyone's problem. And I still hear people talk about things in terms of, well, it should really come out of legal's budget because it's mostly a legal issue. Well, maybe that's true, it's mostly a legal issue, but still it affects the entire organization. So really getting an idea of where the money is going to come from is important, and not just expecting one department to pay for everything. Thirdly, roles and responsibilities, getting an idea who's going to do what is so important, because it's very easy to butt heads with people and say, okay, well, legal should have the last word, or IT should have the last word, or compliance should have the last word. Really getting that up ahead of time, getting to know who should be doing what on this project and what the responsibilities are. Again, I see friction all times whenever there's a lack of clarity as to who's doing what. And then finally, what happens when the project's complete? So say, for example, you finish the project, but now you need maintenance. You need someone to manage the project. Manage the program once it's gone from a project to a program, because all data privacy becomes programs at some point. Who's going to manage that? And in many cases, folks don't even look at saying, okay, well, great, we're just going to give it to person X, we're going to give it to the CIO, or we're going to give it to the CISO. Just adding that on to someone else's duty is not usually a good idea because they're already overworked as it is. So finding out what's going to happen is crucial. Next slide is assemble your team. And there's really two big pieces to this. One is, we talked about the leader already, finding someone who's to be your architect, so someone who has the big picture view, someone who understands all the moving parts to essentially architect the whole thing out and get an idea of what the solution is going to look like. And they're going to draw the project plan, they're going to know what success looks like, they're going to have all those pieces put together. You definitely have to have one vision. If you try to have multiple visions of what success looks like, it's going to be a mess. And again, I've seen this in cases where there's no architect, and so everyone has a different view of what success should look like, and as a consequence, the project winds up looking like a mess because there's no one vision. It would be like trying to make a movie, for example, and there's no director, for example. Everyone's just deciding to doing their own thing. Secondly, a project manager is crucial. Having someone who's keeping track of all of the whys and wherefores and all the fine points of the project, very crucial to have. That person has to be a different person than the architect. So just a project manager to keep track of everything. Again, this is probably second nature to everyone who's on this call, but I'll tell you, without someone who's managing all that and someone you can call and say, where are we? That's where you have all kinds of problems. In terms of departments that should be represented, legal at a minimum, legal, HR, IT security, IT, compliance, audit, and then your lines of business that are affected. I emphasize getting lines of business that are affected because if you don't, when you start making changes that affect them, they're going to push back, and you really want everyone on board so that any change that gets made, you get some consensus, and people can't complain about decisions that they participated in. Let's talk about the team charter. Again, the idea of a team charter is that you're having an overall vision of what the project and the team is supposed to do and what you're supposed to accomplish. And that's something that should be signed off, again, by, at a minimum, the executive sponsor and perhaps other folks as well at the C-suite level. That someone responsible enough to say, okay, I've seen this, I understand what the team is supposed to accomplish. So very important to have these things. And then finally, let me list some of the project killers. Again, these are probably nothing new to you, but I want to cite them because this is, every time I've seen a project fail, one or more of these things has been the issue. So no meaningful leadership. We talked about leadership earlier. No budget clarity, as in whose budget it comes out. No clarity on roles or responsibilities. Bandwidth is another issue. So for example, I often am in meetings where people say, oh, we can do that. And yes, you can do that, but should you do that? Because in many cases, you run out of time. Remember, we've got maybe 6 good months between now and May 25th to really get work done because things are going to slow down during the holidays. And right now, if you're just starting the project, you've just started it, likely you're going to run out of bandwidth to be able to do all the things you need to do. Also, friction between parent companies and subsidiaries. I see this with regularity where the subsidiary is doing all the work and the parent company keeps butting in and saying, well, we want it to look this way. And you see that friction. And that's something that also will kill projects. Not having the right people on board. This is the opposite of a problem with assigning roles and responsibilities, is just not having the right people you need. At a minimum, legal is going to have to be involved. IT security will have to be involved, and HR. Those are probably the 3 relationships or 3 roles that are so important because they have such an impact on personal data. And then finally, not testing or not validating. So not testing what you've done, just going live, if you will, without any kind of testing. For example, say that you want to test your data subject access request process. I would do a sample one. I wouldn't even tell anyone in the process that it's going to happen, and then test it. Have someone send a note saying, hey, give me all of your information you have on me and see how the organization responds. Because in many cases, it's going to be first time they've done it, and it's going to be a real challenge to get everything going the first time. It's a big difference between doing it theoretically and doing it in practice. So I'm going to do a full stop there. Doug, if there are questions or comments or anything, feel free to send them my way. Otherwise, we'll go to the next section. Okay. In that case, so what does success look like? There's 4 components here to what success looks like in my experience. One is having an Article 30 data inventory and data map. So that is essentially a very succinct listing of all of the applications you have that process personal data. Secondly, a third-party compliance with Article 28. So Article 28 gives a laundry list of things that third parties need to comply with. So having that done is going to take a while as well. a state of privacy dashboard, meaning a summary of all of your privacy components. I grouped them into about 12 components, major components, and these are things that you need to be able to look at every day and go, where are we with respect to this? And then finally, a compliance binder. A binder is just essentially a list of documents. It could be electronic, it could be paper, that a data protection authority would want to look at if they want to review or audit what your program looks like. So let's dig into an Article 30 data map. I want to share with you what this looks like. You may have seen this on a previous webcast, but we're going to touch upon this and why this is so important. So if we go to the next slide.
Good. I'd like to interrupt you with a couple of questions.
Sure.
Regarding a DPO, how does the company know whether they need one or not? And there's two follow-on questions. How many companies actually have DPOs? Maybe you could provide some estimate. Is there a shortage of data processing officers, and what are some of the options for organizations to hire and train DPOs?
Let me answer the last part of it first, if you will. In terms of the number of DPOs that are out there now, if you're a German company that you're working for right now and they exceed a certain number of employees, you likely already have a DPO for Germany because that's the root of where this whole data protection officer regulation came from to begin with. So in terms of how likely you are to need one, put that aside whether you're a German company and have that threshold number of people. If you're just a regular company, but you address or handle or process special personal data, let's say, for example, you're a company that handles medical data. Either you're a medical institution or a facility or a hospital, or you're a research lab, or you are potentially an insurance company that has access to all of a patient's data, and you're looking through it with regularity. That kind of organization is going to have a DPO. There's no question about it. If you're an organization that handles other special data, say, for example, that you process, we'll say, criminal records, so that municipalities or countries can look at voter rolls and say, okay, you're a felon, you can't vote, that kind of a thing. That's processing special data. You're going to need a DPO, almost certainly again. If you are processing regular data, and again, the example I use all the time are the companies that monitor traffic on the freeways, because you're processing regular personal data, someone's license plate, perhaps, or just a photo of you driving or what have you, because they're counting the number of cars that are going through a certain area in a certain period of time, et cetera. And then they're doing analytics on that and selling that to the municipalities so they can see, where they need to put in new freeways. So that kind of company that does mass surveillance on the public at large, they're going to need a DPO. So those are really two crisp examples where you're going to need them. If you don't fall in either of those buckets, I would avoid a DPO, because remember that once you appoint one, if they're an internal employee, you're stuck with them. You can't fire them. So either if you have to appoint a DPO, hire an outside third party to be able to do so. If you do, otherwise, make sure you have a data protection manager. Again, this is someone internal that manages the program. It's their desk that stuff's going to drop on. So if there is a data subject access request, if there is a complaint, if a DPA needs to talk to you, a data protection authority needs to talk to you, if there's a legal question. When I was my former company, every single data protection question found me. I didn't even have to ask. People just found me and gave me all kinds of questions about where we were with the program. You need that person at a minimum. Data protection officer, I would avoid it if you don't need it.
Do companies need to register with each country DPA?
They no longer need to. So once we go live on May 25th, the registration requirement is gone. So that's the good news. The bad news, if you want to call it that, is that the registration requirement essentially has been transferred to Article 30. So now all of the data that you would have given the DPAs, you're going to have internally. And what's interesting about this is that you're going to have probably collect more data than you would have had to give to the DPA. I know when I was doing registrations for ICO governed organizations, so organizations in the UK, they didn't really ask a lot of questions. I mean, it didn't take terribly long to do the registration, and it wasn't a difficult process. In France, it was a whole different matter. I mean, just doing one registration was a huge amount of work. And if you had a lot of third parties you were working with, it just multiplied all your work. So this Article 30 data inventory essentially takes the place of that, so that if a DPA calls you and says, okay, tell me what applications you have or what processes you have that implicate personal data, then you're going to have that thing ready to go and be able to share with the DPA. And it's going to have to be very thorough so that you're satisfying their inquiry. Otherwise, they're going to potentially fine you or have an investigation, and it's going to get ugly.
Great. Follow-up question. Does the GDPR apply to data obtained prior to the deadline, May 25th, 2018?
Yes, it does. Yes, it does. So if you're a marketing organization, say, for example, and you've got a bazillion email addresses that you've collected or maybe you bought from third parties, and you want to start sending out emails to everyone saying, hey, here's our latest, ad, or here's our latest, whatever it is. The problem is that unless you had consent, and you can find that consent that you received from the subscribers, if you will, you can't use that data anymore. So you're going to either have to find a way to forensically look back and say, okay, did we get consent, or is there some other basis that is legitimate, a legal basis to process that personal data? If you've got a contract with the party that's on the list, great. Okay, that's a legitimate basis. If you don't have that, you can't use the data, and you can't send them emails asking if it's okay to send them an email. That's been tried. It's been punished. So don't do that. Okay. So here's the data inventory and the data map. So what you're seeing here are what I call the minimum areas that you need for a data map. So what you're going to do is, if you look on the left-hand side, I'm calling this Employee Central. Think of this as your HRIS program. Everyone's got their own flavor of HRIS, but really you have to have a list of what the processing activities are. That is to say, what you're doing with the data, why you're doing it, who are the data subjects. Here I'm using Acme as an example. So full-time and part-time employees, but not contractors. What data is being processed. A typical HRIS program could have hundreds of fields. I've seen some really exhaustive lists. You want to get an idea of what you're processing in practice, not what you could theoretically process. You may even have to have a link from this square, for example, to that list of fields that you're processing, and so on and so forth. So you can see on the screen here all the different information that you're going to have. And as a consequence, it's going to get pretty long. So this is what success looks like. And now this is just 3 applications. So I've got Employee Central for HRIS. I've got Sell Me Stuff, which is for CRM. And then I've got Reimburse Me. So think about your expense report software. That's just 3 applications that implicate personal data. Some customers of mine, I've seen 50 to 60 applications once they start digging. And what's interesting about it is when you start digging, typically you'll find for every program you have, you'll find 2 more programs you didn't know about that process personal data.
So this is a great start. Is there more that needs to be mapped than what's being seen here?
Yes. This is the bare minimum. When I did mine for a former employer, I probably had 30 different fields because, for example, the CNEL was asking for example, things like, well, for every program you have, who has administrative access, who has versus end user access. Or perhaps you have a third parties that have access to this. Well, what third parties, what kind of data transfer mechanisms do they have? So, I mean, there was all kinds of things that I added on. So what you're seeing here is just the bare minimum that you need, but certainly the list is going to get very long.
Great. A participant asks if there's any sort of standard template that's generally available.
There is not. We're still far too early in that process to have a standard template. And even if we did, frankly, I wouldn't be inclined to use it. And my view on this is that this is something you have to create scenarios and say, okay, who is governing us? We're in the UK, okay, so the ICO is governing us. We're in France, so it's the CNEL. We're in Belgium, what have you, and look at the Data Protection Authority and seeing how aggressive they are, what they've punished people for doing in the past, what are the kind of things they've asked for. I would really tailor it to your own organization. I wouldn't just have fields just to have them. Really find out things or go through scenarios of things they might ask. Again, the ICO was a lot less restrictive, for example, in the kind of information that they'd want versus the CNEL, who just wanted a ton of stuff. So you really have to ask yourself, what are the DPAs that govern you, and what are the kind of things you're potentially going to ask, and then work backwards.
We have a question from a participant, and he is asking, what is the solution for a small to medium enterprise in Europe at this point is behind the curve and very fragmented? They are a data processor who still need to do the data mapping and the inventory, which he assumes is the first step.
Yep. Yeah, I mean, we are looking at what success looks like. If you do these 4 elements that we talked about, the data inventory, getting even a basic data inventory with these fields completed is crucial, because that document feeds into a bunch of other areas as well. And as a processor, you're going to have to adhere to Article 28, which is essentially the same requirements that a data controller has. I mean, for all intents and purposes, the two are treated almost the same, if not the same. So it's going to be data inventory in the map, get an idea of what things your application feeds into, what third parties have access to that. Because in many cases, you're a processor, you've got third parties that support you. You've bought technology for them that support you, and perhaps they have access to this data. So you got to find who has access to everything, because that's where you're going to get bitten. Again, a good example is HRIS systems. In many cases, they've got folks that remote in. Okay, they're doing engineering or they're doing something, and so as a consequence, they're getting they're looking at personal data. And so it's a real killer, because now you've got to go and get a third-party agreement for those folks. So the net of it is that you've got to go and do this inventory and do it fast. Just get it done, get your third parties identified, and start getting contracts signed with them or revised with them to make sure that they're on board. You got to work as a team, because if even one of your third parties goes south, then it's going to hurt you.
Got it, Scott. Given that there's, 149 days left until the deadline, I've seen research published about European companies where up to 60% of the companies have not started their GDPR initiative. What are the chances that companies would just ignore the directive? And is there a threshold of pain where data privacy authorities are going to start enforcing?
Yeah, the short answer is that this is going to be driven by complaints. So the more likely you are to get a complaint by a third party whose data you're processing, the more important this is. So I wouldn't expect a kind of grace period. I wouldn't expect any mercy from the DPAs. It's just really going to be a question of how risky is the processes that you're doing to the personal data. How big of a target are you? And if that's you, if that's your industry or that's your organization for whatever reason, it doesn't take much to get a DP in action, because they want to find people so they can make money. I mean, that's just the nature of it. So the short answer is that you can't just ignore this, because you don't want to be that company that gets made an example of. I wish I had better. I wish I had more comforting advice than that. Again, you don't want to be the company that gets to be made an example of. And I read about all these examples weekly, and they're published by the Information Commissioner's Office in the UK, for example. And it's amazing the things I read people are still doing, and they shouldn't be, but they get caught and then they get fined.
Great. Some other questions from the participants. So someone's referencing a comment that you made that various businesses located within the EU need to base their actions on how their government approaches compliance. So how should those of the U.S. Or those of us in the U.S. that do not do anything but have EU citizens go to their websites and subscribe to their newsletters?
Yeah, I get the question. Look at, if it's possible, to get an idea of what nations those folks are from. Are you mostly getting folks from the UK? Are you mostly getting them from another EU nation? And look and see how those data protection authorities approach enforcement. Really, the good news, bad news, if you want to call it that, is that the ICO and the CNIL really are very prolific in writing opinions in general about how to approach data protection. I'm not saying that others are bad, certainly, but I tend to read theirs the most. They have a really lot of good material that's digestible for ordinary people. You don't have to be a lawyer to read these things. So that's my recommendation. I'm sure Germany's got good stuff as well, because they're very proactive on privacy, but I just tend to read the ICO stuff. So I would read the opinions and get an idea of just what the organizations are looking for, the DPAs are looking for when they police and when they punish folks. Also keep in mind too, they may not just fine you, they may tell you to stop processing the personal data that's in question, and that's much bigger of an issue than the money. you can get more money. If they shut down your business, you're out of luck. So keep that in mind as well, as an injunction can be far worse than any kind of fine you could get.
So in the US, FTC can do an audit on my company?
Potentially they can. If you're a Privacy Shield a subscriber or self-certificate, if you will, definitely, there's no question about it. But if you're not in the Privacy Shield, but the DPAs from the EU lean on the FTC politically, then potentially the FTC could audit you as well, or investigate you. Actions that have happened in the EU have also happened in the US. Like, for example, when Google they were doing mapping and they were logging into wireless access points, and I guess they were collecting data they shouldn't have collected. This happened on both sides of the Atlantic some years ago, and they got punished in the EU and they got punished here in the US. So the net of it is that the FTC definitely can come down on you because they're our nation's privacy cop. And even if they don't get the complaint, if the DPA in Europe does, I wouldn't be surprised if they leaned on the FTC to enforce things on their behalf.
So would the FTC be considered a DPA?
They're the closest thing to our DPA we have in the US. It's the FTC for those regulated by the FTC, and then it's the state's attorneys general. They're also considered privacy cops as well as every other kind of cop.
Okay, great. How do you get child consent, and are there any use cases for this? And do you have any recommendations for approaches?
I don't spend a lot of time on child consent. That's a whole subset of privacy. So I just don't have any really good advice at the moment. I talk to folks that are experts with COPPA, which is the U.S. child consent laws, and they are always very good at the things that they advise. I just don't really have any good advice on that.
So there is another question. What is the risk or probability of denial of service order being issued, as this is a stronger reason for compliance in some cases for small to medium enterprises?
Denial of service orders, meaning an injunction? Is that what the question is? Let's assume that that's what they're asking. I presume that's what they mean by denial of service. I don't know what the percentage chance is of an injunction. Typically speaking, what happens is that when a DPA comes down on you and is going to punish you, they're going to ask you to make changes and to probably pay a fine. It's usually when you won't cooperate or when the violation is so egregious that money won't change anything anyway, then they're likely going to shut you down with an injunction. Again, it would take a lot to do that, is my estimation, but it's certainly well within the realm of possibility.
Got it. So you answered in the context of his clarification, which was stopping business activity.
So again, if you've been on a prior webcast with us, then you've seen what a challenge is that finding data because of the idea of online identifiers. It's not just regular data like your name and your address or social security number. If it was that, it'd be less of an issue. Here, electronic devices have all kinds of identifiers that you can trace people or trace back to people eventually. So IP addresses, browser cookies, mobile IDs are great candidates for this, MAC addresses, all these things you're seeing on the screen, all great examples of things that you have to hunt down. And this is really what the challenge is when I work with clients and they realize the scope of this just got a lot bigger. And because they think, oh, we've got 3 applications, we've got an HR system and a CRM and expense management, we're good. Well, no, not so fast. There's a lot more to do. And it's when you find these third-party identifiers, like log files, for example. Some folks have gigs and gigs and gigs of log files they generate every day. And so then the question is, great, now we need to go and dig through these things and find the identifiable information. So this is a big challenge, and this is what will expand the scope from X to 3 times X of your data map and your data mapping process as well.
Scott, do you expect the online identifiers to continue to be a problem for privacy and security professionals? Yes, absolutely going to be a problem. And in fact, we'll see more of these because every device that runs on electricity generates personal data typically. I mean, it's amazing. It's funny, when I was in the electronic discovery world, that was really our guide, was that if it was powered by electricity, it produced discoverable data. And essentially the same model works here for personal data because so much of the things you're seeing on the screen are now personal data. So the short answer is yes, everything we're seeing is going to be personal data in some form or fashion. So what success looks like, just a couple things that I want all of you to understand. Once you've got your data inventory and your map,
it's going to feed into other areas here. That's why this is such an important thing to get done first. So, for example, looking on the screen, we see the different articles, like Articles 15, 16, and 17, which is your data subject access rights. If you want to be able to meet those rights to when someone sends you a DSAR, data subject access request, you want to be able to have the information about them. A data subject access request is essentially a request by data subjects asking, okay, company X, what do you have on me? What information do you have? And depending on the relationship you have with that person, it could be a lot. If they're a customer, then you may have all kinds of data about their shipping address and their billing address and their personal data, anything that may be used to customize your products or services. It could be a long list. And the problem is that that's going to be in all kinds of different databases. And so it's a total fire drill to go and collect all this if you get hit with one of these. That's why having the Article 30 record is so important. It's going to take a lot of time to collect everything and get it together and package it up and send it to that person. In some cases, these efforts, I've talked to other practitioners where they said with their own clients, a single DSAR absorbed about $25,000 of time, a professional's time to get everything packaged up. And that was for one DSAR. So this can be a total time sink if you don't have this information already mapped out ahead of time. For these other articles, I won't go through all these, but the same principle applies. Third-party management, information security, all these things that require good data. If you do have a data protection officer or a manager, almost certainly you're going to have a manager at a minimum. He or she's going to need all of this information to run their program. So breach notification, if something bad happens, you better be able to provide to the EPA useful information in 72 hours. Just saying we got hacked is just not going to cut it. And again, I'm not going to cite any recent hacks. I'm just going to say that when a hack happens and personal data is lost, it's a mess. And unfortunately, companies still don't do a good job of it overall. So this is a great opportunity to do a better job by having that Article 30 data ready to go.
Okay, there's a question. Does DSAR include personal phone call recordings like those done for call centers by large companies?
Good question. DSARs, generally speaking, you can make the argument that a DSAR, data subject access request, is really going to ask about the kinds of data, not the content of a conversation that you're having. Now, I can also make the argument that as a data subject, I want that recording. Say hypothetically that you have a broker-dealer that's recorded a phone call. I want access to that. I want to be able to, maybe I have a dispute with this person. So you can make a very good argument that DSAR should include everything. They should include not just the kind of data that's being processed, but also the contents of that data. So I don't know how the ICO handles it. I haven't dug into that particularly, but I would be prepared to produce everything. Think about in litigation, how you have to be prepared to produce everything. I would say the same thing applies here. If they don't require it in the UK, that's great. If they're only requiring just the kinds of data, then you're ahead of the game. So I'd be prepared for everything because almost certainly as a data subject, I'm going to ask for everything.
Follow up to that, the participant's comments. He has seen companies in the UK ignore a DSAR under the Data Protection Act of 1998.
Yeah, I would not do that. I just would not do it. And my advice is to go to the ICO site and look at all of the fines that were handed down. And you can see that they've got some pretty big ones there. There was one that happened. It was a medical institution and his name escapes me now, but it was actually a UK subsidiary of a US medical institution. And they had unencrypted data that was in a server in India. And people that were Googling themselves were finding that data. And so they punished them pretty severely. I would not ignore a DSAR. I mean, you're just giving a DPA an opportunity to go fine you. So that's my view anyway. So what success looks like third parties. So Article 28 gives you a laundry list of things that as a third-party processor, your third parties are going to have to provide you. So for example, they have to guarantee the security of the data, of your personal data that you're giving to their care. They have to operate with written authorization. So your contracts are going to be very specific as to what you can do. And where this is important is if you don't have this, potentially a third party can do all kinds of crazy stuff with your data. They can potentially resell it or do other things or do analytics with it, but not do a very good job of anonymizing it. And there's all kinds of things they can do. And you've got to really think about this ahead of time and say, look, you will do exactly what I tell you to do and nothing more. And if you want to do more, then you have to come back and get our okay. Otherwise, you risk a third party running amok with your client's personal data or your employees or what have you. So in the contract, these are just some things that you'll have to have. You know, we must talk about instructions, confidentiality agreements that their employees have to have with their own company, protection by information security. Again, getting okays to see other processors and to use them. Assist the data controller when they're in trouble and they need something. In many cases, the third party is going to ask you, or you're going to ask rather a third party to help find data that maybe was lost or is being processed improperly because the DPA is breathing down your neck, and so they have to assist you, the data controller. And if you go to the next slide here, you'll see there's a couple more things I've mentioned. So in the contract, delete personal data when you're done processing it. Make sure that you're providing compliance information if the data controller asks for it. And then other things like notify the controller if there is some kind of infringement or loss of data and so forth. So essentially, the third party is going to have a laundry list for Article 28, and you're going to have to take a look at that and make sure that every single contract is up to snuff. And this is tough because a lot of times third parties don't want to cooperate. And this is where I used to spend many, many, many hours on the phone arguing with third parties as a lawyer, just saying, guys, you got to cooperate. So this is the problem. This is why this has to go on your critical path that we'll talk about in a minute. Let's go to the next slide, Doug, unless you have questions.
Yes, so a couple questions. First is, what if I need to keep the data for an FDA audit?
The short answer is that you can make the argument, and I think it's a good argument, that regulations in the U.S. are designed to protect data subjects, and as a consequence, you should be able to keep that data because it's still useful. Okay, because remember, you wouldn't want to keep data any longer than it's necessary, but if it's necessary, you can make the argument that having obeying U.S. regulatory requirements helps the data subjects, and as a consequence, you should be able to keep the data for as long as the U.S. requirement lasts. That's the argument I would make on behalf of my clients. Now, is there any jurisprudence that says that's going to win the day every day? No, but that's the argument I would make. That way, because right now, all the GDPR really says is don't keep personal data longer than you need to. So you can make the argument that you need to keep it in order to satisfy U.S. requirements, which are really to benefit the data subject.
If you contact a company, say a bank, that only has a presence through a foreign call center, and they're not trained well, probably have no understanding of compliance, who the compliance officer is, or at worst, as some organizations may have experienced, no understanding of who to address internally with the DSAR or what the DSAR process is there a big fine for this kind of lack of knowledge or ignorance? He finalizes this by saying this is a lack of cooperation through company ignorance. Any comments?
The short answer is potentially. Again, I'm not aware of punishments simply for having a poor process for accepting DSARs. Usually there's someone who's tried to accept a DSAR or tried to ask for a DSAR or make a request is a better way to say it, and they haven't gotten anywhere. That's typically what lights the fuse. So it's not going to be having a poor process per se. It's going to be some aggrieved data subject complaining to their DPA, and that's what's really going to start this whole process. So that's where, if they get fined at all, it's going to be for not cooperating in a timely manner. So that's the best way I can couch the answer. Information Commissioner's Office, the ICO. That's the website that I read really the opinions of the ICO and the CNIL, which is the French version of the ICO, if you will. And they have a lot of stuff in English that's very good reading. So those are the two sites I go to just to get good information about how at least those agencies view processing of personal data.
Can you tell us anything on the right of portability?
Yes, I can tell you that we have noodled about this quite a bit at my company and with our clients. And it seems that the right of portability really, I don't want to say it doesn't have a lot of substance. It doesn't have a lot of, it doesn't have wide applicability in the sense that you have to ask yourself, what kind of data would someone want to take with them? And in many cases, we have a hard time finding it. I've just asked this question many times to clients. Well, if someone left you as a I don't know what you want to call it, as a supplier perhaps, or a provider of services or goods, what information would a customer want to take? and they haven't been able to tell me in any instance that there's been anything someone would want to take with them. So I think it's going to be uncommon that data portability is going to be an issue. Again, this is just my experience. Consumer applications are probably going to be the best version of this, or the best scenario for this. But again, I just haven't run into anything where this has been relevant. Now, it's early. Talk to me in a year. We may be that completely changed. So let's go to the next slide.
I'm sorry, Scott. I actually thought of a question. So you had mentioned before that third-party remediation tends to consume a lot of time. Is the problem just around data mapping or other things?
No, the issue with third parties is political, is that they don't want to cooperate. I mean, that's basically it, is that or they think, I hate to say this, they think they're smarter than you. I've been in so many arguments with folks who think that their reading of the law is better or superior and they don't have to comply with the law or whatever, but they're always finding an excuse not to comply. That's basically it. They're jailhouse lawyers, as I call them. And it creates a lot of problems because you depend on these organizations to help you in so many ways, to identify data, to make sure they have a correct data transfer mechanism. There's a lot of fights over those. It goes on and on. That's why these folks go on your critical path, because they take so much time. You could spend 6 months arguing with some of these folks, as I have. This is a state of privacy dashboard, and the idea is that you'll put your main areas of things that you need to comply with, and then you'll put the elements and then the current state. And the idea is that, and this is just the first piece of it, obviously there's going to be more. You'll have your remediation plan and all that, but this is the idea that this is something you want to look at every day and say, okay, where are we with data subject rights? Is our DSARs all set? Have we tested it? If not, we need to advance our progress there. The idea is this is meant to show you and people you work with in your organization where you are in terms of your state of privacy and making sure that everything is going towards a green. And you're probably going to have lots of yellows and reds right now, but you ultimately would like to have everything green. This is something that really forces that issue to the fore. So that's why I recommend everyone have one of these.
I understand you're saying this is an internal document, but isn't having the red, yellows areas going to look bad to DPA if they happen to get a hold of the state of this privacy view?
It very well could, which is why I recommend in many cases that you have essentially attorney-client privilege, and that this is done under that letter of attorney-client privilege with your general counsel's office. That way that you can do this. Potentially also being able to say, look, this is a working document and we're using this as a document to make sure that we're improving our privacy program. I think that's another way to couch it if you don't want to use this as part of under attorney-client privilege. But either way, this is crucial because having those reds and yellows really forces everyone to say, look, we got to get this thing fixed so that we're lowering our risk level to something that's acceptable. So compliance binder, I won't spend a lot of time on this. Really, this is a collection of your policies, your procedures, essentially everything that you're going to need to be successful in your privacy program. You're going to have documented. It could be an electronic binder, it could be paper, it could be both. It's the idea that, okay, DPA wants to look at your program and they want to say, okay, well, what's your privacy policy look like? Do you have an acceptable use policy? In some cases, I'll give you an example. When I was working with folks in Canada, you have to have an acceptable use policy if you want to require employees to not do certain things. Okay, so not, for example, surf the web when they should be spending time working or things like that. You have to inform them ahead of time using an acceptable use policy. Otherwise, you can't punish them for essentially goofing off at work. So things like that, I found out that you have to have. So as a practical matter, you want to be able to have policies and procedures. If you go to the next slide here, there's other things as well that you'll have. So your plans, notices, whether it's a mobile version or on your website, within your facilities. In some cases, you'll have to post a privacy notice. So the idea is have this all ready to go so that a DPA can look at it and go, okay, you guys have a good program here. You're doing your job. I'm going to go bother someone else. Versus not having a compliance binder and saying, wow, you guys didn't take this seriously. We're going to start auditing you. That's the idea behind a compliance binder. So it really has a functional aspect of helping you run your program, but also it shows that you're acting in good faith.
Would you recommend a procedure for the right to be forgotten?
Absolutely. That should go very high on the list, because believe me, everyone seems to know about this. I get questions about it every day. So yes, make sure that your DSARs and your right to be forgotten are at the top of the list, because you can bet come May 25th, they're going to be firing those things off. I mean, and right now, as a practical matter, you can already fire off a DSAR. I mean, that's part of the data protection directive, but I think that right to be forgotten is going to be one of these things that everyone's going to want to jump on and see how far they can push companies to adhere to. So just an FYI on that, that's going to be a big deal come May 25th.
Got it. Another question. Suppose you have a third-party certification like ISO 27001. Is that enough evidence for the compliance binder?
It's not enough. It's great to have. Certainly an ISO 27K cert is great to have. I'd recommend that if everyone has one to begin with, make sure that goes in your binder. The problem with an ISO 27K, 27001 cert is that you have to identify which systems are in scope. So if you've got personal data on a system that's not in scope, it's not going to help you very much. So make sure that if you're going to put in the binder, that the data that you're processing is covered by that. Otherwise, you kind of defeat it yourself there.
Regarding subcontractors, do you have best practices regarding who should bear the cost of the right to access, modification, deletion between the data controller and data processor?
I would tend to split it evenly. Now, it's funny because there's two questions that come up. One is that who should bear the cost, and I say split it evenly. The other one is indemnification, because you're going to see both sides are going to try and get each other to indemnify one another, and typically they cancel out and they both say, forget it, we're not going to do any indemnification. So in answer to the first question, it's going to be split evenly is my guess is how it'll work. Now, if you're a really big company and you subcontract out to a small one that doesn't have the bargaining power, yeah, you may push all the costs onto them for DSARs and for everything else, but you're gonna have to negotiate that. And typically, it's just whoever's the best bargaining power is the one that's going to win that game.
A few more questions. So, do you think companies will end relationships if people ask for DSARs, treating that person as troublesome, especially as a DSAR could be costly?
They could end relationships, but they're still going to have to comply with the DSAR. So that's the thing, is if they don't want to comply with it, then that person, that troublesome person, as it were, is going to potentially go to the DEPA and complain. So yeah, they could. That's entirely possible, but that is not going to eliminate the need to comply. And someone else may make the same request, and are you going to just fire all your customers? So that's the decision you got to make.
What's the range of a DSAR cost?
It could be a lot of money. It depends on how many professionals need to be involved. I mean, for example, HR, if it's an employee that's doing it, HR data is going to be there for sure. But even if it's someone who's a job applicant that never got hired, you're going to have to still have HR involved. You're going to have legal involved for sure. IT is involved, IT security. It's going to be a big effort. And so, yeah, $25,000 worth of professional time. That doesn't count third parties. If you want to bring in a consultant firm, like we get brought in to help, that's going to cost more money. So it's going to be a lot bigger than you think. That's why preparing for it now is so important. Okay.
Just a couple more questions. Do I need cookie consent for websites, including mobile apps?
Yes, you do. But look at the e-privacy regulation when it comes down. It's still being baked, as it were. Right now, that's going to make some big changes to how cookies are addressed. But in the short term, yes, get cookie consent for mobile apps and for your regular website apps, or websites rather.
Great. So they have a question about your answer. So when an HR department says, yep, we'll keep your details on file, can you get the type of depth of information of who saw the CV, for example, in their comments as part of the job application process?
That's a great question, because you're thinking this is really a little bit like HIPAA, where you can get a list of all the people that have looked at your records. The short answer is I don't know. It's funny, this is still fairly new. I don't think people have really taken advantage of DSARs very much in the past. And so this just isn't a terribly well-developed area of law. So the short answer is I don't know. We're going to see how this develops. But I would prepare for the worst. So starting, I know we only have 3 minutes left. So we'll probably have to do a part 2 to this, Doug. But let me just hit these 5 areas, because this is really what you guys need to know. Decide whether you want to get attorney-client privilege or not early on. I think that's important. There's some benefits to it. Talk to your GC and see what they say. Also, some cases that you either want to decide whether to do an assessment or just go with what you know. If you do an assessment, it's going to take a lot of time, but it's going to reveal a lot of things that you wouldn't have thought of otherwise. So consider whether it's time to do an assessment or just identify the areas you already know are trouble and just go after them. Establishing your critical path. If you guys leave with nothing else in this call, you've got to get your critical path. You've got to get it. You got to get it now. And when I say critical path, meaning all the things that you have to do and what's the maximum time those things could take. That's your critical path. So, for example, getting your European Works Councils on board, that may take a lot of time. Collecting documents may take a lot of time. Just all the things that need to be done between now and May 25th, you really want to write that out now and whiteboard it and get an idea of how long everything could take. If it's going to exceed that time limit, then start chopping things off and determine what you can do between now and then. But here's the problem, and I've learned this the hard way. If you try and do your critical path later, it's going to find you. You're going to find out things that you should have asked 6 months ago that now you wish you had asked. So this is why you really want to find all those things you need to do, whiteboard it out, and see what you can accomplish between now and then. Fourth, execute. And so execute means just get everyone together and just start doing this thing. Stop talking about it. Just start executing it and getting it done. And then finally, test and validate. If you guys leave with nothing else besides what I mentioned earlier, if you haven't tested it, it doesn't work. You've got to test things like DSARs and you got to test them with people not knowing that it's a test, because that way they can say, oh, wow, it's real. Let's go see if this works and find out where things don't work. So definitely you've got to test this stuff. Otherwise, you're going to test it with real people and it's going to be a big surprise. So again, why attorney-client privilege? The short answer is because in many cases you want to protect what you're doing, because you may reveal things that need to be addressed by your attorneys and by outside counsel, and they want to protect that. So you always want to ask them ahead of time if you want this under a letter of privilege. So make sure to call inside counsel and see what they want to do. Assessment or no assessment, again, just as a practical matter, assessments are great in the sense that they're going to open up a lot of doors and find things that you wouldn't have found otherwise. Some organizations say, we already know what our problems are, we just need to fix them. And if that's the case, then don't do an assessment, just execute your project. So it depends. If you don't know what the scope is of your problems, though, spend the time doing assessment. The more thought you put into that, the less work you'll have to do down the road, or at least less repeats of work you'll have to do. And critical path. So here's a couple things that should be in your critical path. So we talked about EU Works Councils. They can drag things down for months and months, and they can even veto, in some cases, your whole program. So, for example, in Germany, they can veto your privacy program. So you definitely want to get them on board early. Also, identify your systems and scope. As I mentioned earlier, once you start digging, you're going to find all kinds of chained applications that feed into other applications, applications that are fed by other applications you didn't realize until you start talking to your colleagues in other departments. Identify your third parties. As I mentioned earlier, you're going to find that probably 40 to 50% of your applications have third parties that are involved. It could be your CRM provider. It could be a marketing list service provider, but there are so many third parties that people don't realize until it's too late. And then gathering documents. And this can be a real headache because in many cases, there's not a contract manager. And so you have no idea where the contract is for a certain third party, or you don't know who owns the privacy policy. Is it HR? Is it compliance? Is it legal? Who owns it? A lot of times people don't even know who owns a given project, or I'm sorry, a given policy. So go gather documents, put this all on your critical path. It's going to take longer than you think. I can tell you that much. Let's go to the next slide. So execute. So when we go and look for personal data and mapping it, you want to map for every application or any process. Say that you're a third party and you do one thing, okay? And you're not necessarily, maybe not even necessarily electronic, okay? It could be a paper process, but you're doing something, you're manipulating or processing personal data, storing it, making changes to it. It's still something that's in scope. So make sure that you identify all the different applications or processes. Who are the chain? What are the chains that exist? Who are the third parties that are related to this? Interview both your business and your technical owners if you've got them. Business owners use this on a day-to-day basis, and so they know that end of it. The technical owners know the back end of the application and know what's going on behind the scenes. So interview both of those folks. You may interview the third, if it's working with a third party, they'll have technical folks that you'll be working with. Also, validate with data discovery. It's not an accident that a data discovery company is hosting this webinar. Data discovery is crucial to go and find data that you're not going to find any other way. It's amazing. I've used data discovery in the past. It's amazing how much stuff you find when you start looking. You find things you had no idea were there in places you didn't know exist. So always a good idea to validate. And then for contracts and similar agreements, send them off to legal. A couple things that are high on my hit list. Making sure that the third parties get very specific instructions on what to process, that they've addressed the transporter transfers of data. So for example, using Privacy Shield, using model contracts, that's a separate discussion above and beyond anything else is just transferring the data. Information security, how are they securing the data? That's important. I always ask for a profile. I say, give me a profile or give me your posture on information security. And that really tells me a lot, because if they can't produce that, and in many cases the third party could not produce that, I said, sorry, we can't do business with you. It's obvious that you guys don't have your ducks in a row. And then finally, making sure you address sub-processors, and we talked about this earlier in the webcast. Sub-processors can get into all kinds of trouble. If your processor outsources to another party, and it's not uncommon, you've got to know who that company is and make sure that they're on board with all the same requirements that you have to adhere to, and making sure that they know they can only do certain things with the data, otherwise they potentially could run amok and get in trouble. Go to the next slide. Address GDPR specific requirements. I've given you 5 here. There's about 12 major areas that we touch upon when I do consulting engagements, but I'll just give you these 5. So cross-border transfers, I just mentioned things like Privacy Shield or model contracts. Data subject rights, DSARs, are very high on the list. Breach notification is going to be high on the list as well, because now European companies or companies that process data subject data are going to be required to meet the breach notification requirements within 72 hours, which is a really, really tough stretch. Article 32, information security. So that's both administrative controls like your policies and procedures we talked about earlier in the webcast, and also technical things like multi-factor authentication, which seems to be the big thing right now. For some reason, that's back in vogue. On the data protection impact assessments, if you have areas that are particularly high risk, then this is an area where you're going to have to address using a DPIA.
Is there a particular order to address these in?
Okay. I would put DSARs at the very, very tippy top of the list, because you'll be getting those. Cross-border transfers, if you haven't addressed those already, you really should. And breach notification, I would probably put very high as well, just because it's going to happen. You're going to get breached. It could be as losing a laptop, but you're going to get breached. So I'd put those 3 probably at the very top.
Okay, thanks.
And so as I told the audience, if you haven't tested it, it doesn't work. Make sure you test these things. It's funny, when I was working way back in the discovery world, I heard stories of people that got hacked or whatever and tried to restore from their backup tapes, and they had never tried it before. It was like the first time they ever restored, and of course it didn't work, and it was just a disaster, quite literally. So if you haven't tested it, it doesn't work. Make sure you test all these things we talked about earlier, because until that point, they don't work. So just a couple thoughts here. This project is bigger than you think. Believe me, once you start digging into applications, you're going to find all kinds of stuff. So start now if you can, because it's just going to grow. There's no question about it. You're short on time, stick with basics. Know where the personal data is, who's got it, who has access to it, how it's being protected, because those are the questions the DPA is going to ask you. Make sure you can answer DSARs, because people that want to mess with your company are just going to send those in on May 25th just to mess with you guys. So just be warned that DSAR is very high on the list to do. And if you don't have a true privacy policy, I'm not talking about a privacy notice, but a privacy policy, so something that you can enforce, make sure that gets very high on the list as well, because it's an important control. Even though it's not per se required under GDPR, it's implied that you have that as a control, because if you don't have a policy on how you address personal data, how can you protect it? So those are my conclusions and the next steps for all of us in the audience.
Great. Scott, can you spare an additional 5 minutes to answer the questions?
Sure.
Most of the attendees stayed on, and they've been asking these questions, so I thought
Sure.
Okay, great. And I'll go ahead and just start launching them. So the first question is, how long after the May trigger date might the regulators be most lenient as part of the ramp-up process?
I think as soon as they start getting complaints, they're going to go after them. No question about it. And believe me, the EU data subjects, which are really people that live in the EU right now, know about this stuff. And I'm concerned that they're really going to start pressing third parties and people they do business with for DSARs and for other things as well.
Okay, next question. How might unions use this process to benefit companies?
When you say unions, I presume you mean trade unions? Is that what the...
That's what I would assume, yes.
Okay. Well, really the trade unions involved are going to be works councils, if I understand the question correctly. And they can benefit the company by really requiring the company to protect everyone's personal data, so employee personal data, but also they can benefit clients as well. What's interesting about works councils is that they can opine on all kinds of policies, not just on things that pertain to them, but to protect the public in general. So they can really use that their power to protect the public by saying that your information security and privacy really has to be very robust.
Okay, great. Next questions. Are there any good reference sites for how to word statements on their on this participant's website about cookies? Do they need to capture opt-in for placing a cookie on a user system? Also, if they have a user request for a subscription to a newsletter, for example, how do they capture the opt-in other than the standard sign-up date time data?
Boy, there's a long answer to that. So I'm not going to be able to be very concise about it. Unfortunately, for capturing information, everything has to be opt-in, in my view. You don't want to rely on quote-unquote unambiguous consent. You really want to have a little checkbox that the end user checks. Don't check it yourself. Make sure the end user checks it to say, yes, it's okay. Unfortunately, that's as much as I can give you. There's a lot to talk about on cookies that's probably better for another webcast.
Great. So he further adds, he's looking for boilerplate language, but your advice is going to be the same, right?
Yeah. For boilerplate language, here's what I always did: is I used to go to law firms' websites that had cookies, and I used to just copy their stuff and use that as a starting point, and it worked out very well. So yeah, obviously they've done their homework already, so you don't have to.
Next question, how much is internal project management process and project management skills an imperative in getting the solution in place, as cybersecurity is also about project management?
Project management is huge. You must have a project manager for this. You just trying to everyone kick the ball on their own is going to be a disaster. If you have nothing else but a leader and a project manager, you're still in great shape compared to not having either one of those. So yes, you must have PMO skills. If you don't have a PMO, you must have PMO skills. Otherwise, this is going to go south.
And again, thank you very much, Scott. Great content, and thank you again for your time.
Yeah, absolutely. My contact information is at the last slide that you'll see whenever you get the slide deck.